Hello, my friends. Welcome to today's conversation with constitutional law professor Eric Segall. The Legal Eagle joins me today to talk about three major issues. Number one, the case that was argued in the Supreme Court yesterday having to do with domestic abusers' right or access to firearms, guns. Number two, we talked about Judge Bill Pryor on the 11th Circuit Court of Appeals, racism and runaway federal judges. And then, of course, we discussed all of these court challenges in different states trying to remove or disqualify Donald Trump from being on the ballot because he violated Section 3 of the 14th Amendment and thus shouldn't be able to be on the ballot. Three big issues with Eric Segall today, and I'm going to get right to the interview. I didn't have a chance to do an opening news because yesterday, of course, was Election Day, and I was working on that and of course, on the podcast all day long, and had to go to what I hope will be a celebration party for my local Democrats that I've been working with for over a year. So really nerve-wracking day, and hopefully the outcomes will be great. Looking forward to covering all of it on tomorrow's episode of Stand Up. But right now it's time to get to the Legal Eagle, constitutional law professor from Georgia State University, the author of two excellent books, Originalism as Faith and Supreme Myths, which is also the name of his excellent podcast, which you should listen to, Supreme Myths, that is. Follow him on TikTok, where he's great, of course, Twitter, and let's get to it right now with Eric Segall. Yes, so we might not know election outcomes because we are taping on Tuesday night, but we do know a very consequential thing that happened on Election Day at the Supreme Court. And Eric Segall is here to talk about this outrageous argument, and he forewarned me he's in a mood, folks.
In a mood, but it's not because of that case. I've been in a mood in that case, the Bruen gun case, only for about a year.
Oh.
I'm more in a mood for more novel events, but let's talk about the gun case first, if you want.
If I want to. I mean, is the other two of three, talking about three issues today, how could anything be more consequential than the case that was argued today at the Supreme Court? I mean, I know one has to do with...
it's super important. I wasn't meaning, I was not suggesting. It's just that this nightmare, this absolute horrific decision of the Bruen court last June, which told the American people and all the state courts and the Congress and all of us that gun laws today can only be upheld if you can find a similar gun law from 1791 or maybe 1868. That decision has been here for a year. It has wreaked havoc in the lower courts. I've written like 27 blog posts about it, a couple of articles, went to two symposia in the last 3 weeks. No, you're right. That case itself is really horrific. The good news is today the Supreme Court showed every signs of backing away a little bit from that decision. So let's start at the beginning.
Yes.
In this country, sometimes, unfortunately, domestic violence is a huge problem. And something that has not been mentioned enough and was not mentioned today at the court is this. State prosecutors and local prosecutors do a terrible job when it comes to domestic violence. And they've admitted that to the court in previous cases, wanting federal help. There was a case a long time ago about the Violence Against Women's Act, and the states, 36 of them, basically said, yeah, we do this badly. Please help us. So domestic violence is a huge problem. Turns out you're 5 times more likely to be dead if you're a woman in a house with an abuser if there's a gun in the house. 5 times more likely. We all know that people who are dangerous to their loved ones or to the public shouldn't be armed. Despite all of us knowing that, the Fifth Circuit Court of Appeals, otherwise known as the 1791 Court of Appeals, issued a decision that said that even though a person, this guy, Rahimi, who was subject to a domestic violence protective order, he could not be de-armed because, I don't really know why, because there weren't such laws in 1791 or 1868.
Zaki Rahimi's transgression with guns, the Washington Post writes, detailed in the government's brief, range from the terrifying shooting at a witness who saw Rahimi drag his child's mother by her hair into his car to the bewildering firing a few rounds into the air outside of Whataburger when his friend's credit card was rejected. This is the guy?
This is the guy. Now, you have to understand that the panel included Judge Ho, who, other than Justice Thomas, it may be the worst judge in America. And Judge Ho is trying to get on the Supreme Court, so he's going to do everything he can to do that. He doesn't care about what actually happens in the case.
You're talking about the judge in the Fifth Circuit, Judge Ho.
Yes. But here's the good news. The Supreme Court has been reversed. See, Dr. Doom and Gloom is here with a little bit of good news.
Oh.
The Supreme Court has been reversing the Fifth Circuit at a reasonable rate. They know that they're nuts. They know they make America look bad. Think about headlines around the world. United States court holds person subject to domestic violence restraining order has the constitutional right to own a gun. Think about how stupid that is, right? So no other country in the world that's free would ever do that. And that was pretty much the attitude today at all. I just got through tweeting the entire, I couldn't listen to the argument live, but I did read the whole thing, every word. I just sent 25 tweets out about it. And even the conservatives, except for Alito, were scrambling to figure out a way that this isn't the dumbest decision ever, because we all know it's the dumbest decision ever. The biggest, strongest argument against this law.
The dumb decision being what the Fifth Circuit decided about whether or not a domestic abuser can have a firearm, and that decision only based on the Supreme Court before it deciding on the Bruen case. Now it comes back to the Supreme Court, and they're like, wait a second, what's going on here?
Right. But not a domestic abuser. I don't want to mislead anybody. Someone who is subject to a domestic violence protective order. Listen, so Clark Neely, who's a friend of yours, friend of mine, been on the show many times, and is the most thoughtful Second Amendment person I think there is around. He works for Cato. Clark began his amicus brief basically with the statement, of course, dangerous people can be disarmed. Now, that's not Segall.
Legally, Clark is saying, of course, if people are dangerous, we can take their firearms.
Yeah, I'm making the strongest argument possible for this law, Pete. I want to make it the best I can. I don't want to give short shrift to the strongest argument. Now, I think that strong argument's really weak, but this is the strongest argument there is. Clark argues that the procedural protections in place to issue domestic relations protective orders, first of all, vary across all 50 states. That's a true statement.
Right.
Sometimes they come in mutual. Both parties are given a domestic violence restraining order because the judge is like, God, you're both crazy. Get out of my courtroom. Don't talk to each other. And Clark says more than that is needed to take away a gun. I don't believe more than that is needed to take away a gun. But even if we accept Clark's argument on its own terms, then the answer is to challenge the state procedures that issued the protective order, not to challenge the federal law at issue in this case, which says if you are the subject of a protective order, you can't own a gun. Because we all agree, a lot of people, and Clark agrees, a lot of people who are subject to those kind of orders are really dangerous and shouldn't have guns. If Clark or anyone else feels that the procedures to determine that are inadequate, that's a state law issue. And by the way, the federal statute requires notice that this is happening to you. In other words, you get a right to be heard before a protective order is issued under the federal law. So I think Clark's procedural objections, if you assume that having a gun is a constitutional right, which I don't, but he does, but that's fine, and the court does, even if that's true, then attack the state procedures. That's fine. Don't attack a federal law that is saving women's lives as we speak.
Right. Yeah. You're going to be debating Clark, right? Where? When?
At Georgetown. My understanding is there's a place right next to the Georgetown campus in D.C., not the law school, but the college. It's called the Car Barn. Say that 10 times fast. Car Barn. And Clark and I always have fun. We always learn from each other. We make fun of each other, and I think it'll be a lot of fun. Also, this is one of my few gigs that's for undergraduate students. Oh. I'm very excited about that. This is not a law school gig, so we're going to make this, obviously accessible to college students.
Well, here's the big headline. We could go into the case and the arguments that were heard and how painful it was to hear some of those arguments, and also interesting to hear Judge Ketanji Brown Jackson anytime, much less on a case that she wasn't on. She wasn't on the court when they decided Bruen 6-3. Now she is. And what do you want to say about her reaction? Sorry.
Well, there's a little bit of interesting about a lot of the justices. At one point, Justice Alito asked three hypothetical questions. And then Justice Sotomayor said, but none of that's in this case, right? And that was kind of a nice gotcha moment, and Alito deserved it. Justice Jackson today, more than Kagan and more than Sotomayor, who dissented in the Bruen case, Justice Jackson today really went after the Bruen history only test. And I understand why she's doing that. It's a really, really good reason why she's doing that. It's because she's smart. And anyone who is smart should be wildly offended.
Explain, if you could briefly explain the history-only test that they applied in their decision on the case at Bruin.
In Bruin, so I have a piece coming out in a law review, and then I send you a little piece I wrote for a place called Jurist. The irony of Bruin, and for people who have been listening to me on your show for a while, they can understand why this got me so riled up. The irony of Bruin is that in the name of originalism, Justice Thomas wrote an opinion that is the most anti-originalist opinion in the history of America. Ever, really. It's the most anti-originalist opinion ever.
But he's an originalist.
So are all the conservatives except Justice Roberts. Listen, Pete, if you and I are having a discussion about rights in 1791, if we're talking about rights, what we're going to talk about is there are some rights given to us by God. There are rights given to us by the government. There are natural law rights. But wherever they come from, the public policy benefits of regulating that right have to be balanced against the importance of the right. That's how everybody thought. That you don't, what you say is, okay, this right to free speech, for example, it's really important. It's not the most important right ever, but it's really important. How serious is the burden on the right? If it's a serious burden, then that's one thing. If it's not anyway, it's a balancing test. And that's all of constitutional law. In the Bruin case, Justice Thomas ignorantly said, and for some reason the other five joined, that balancing test is not allowed for Second Amendment cases. We're not allowed to ask what the government's reason for the law is. Think about that. That's Justice Thomas talking, not Segall. We're not allowed to ask why the government passed the law. All we can ask is there a similar law in 1791 or 1868? That's not how constitutional law is done. It's not how this court does it in First Amendment cases and other cases. And it's absurd because what does it mean to say, was there a similar law in 1791 to laws today about AR-15s? Since there was no such thing as an AR-15, since they couldn't conceive of an AR-15, since they couldn't conceive even you know what? Let me give you a Justice Scalia story for a second, Pete. This is really good. This is right on target. There was once a Fourth Amendment case where somebody was stopped and searched. Now, the rule is police can search you for a gun if they stop you to protect themselves. And I'm in favor of that rule. I don't want police officers being shot, so they can pat you down for a gun. But that's a longstanding constitutional law rule. Police can do that. In that case, when they were patting for the gun, they found some drugs. And the issue was, are the guns now the drugs admissible because they were looking for the gun? The court gave its ruling. In a concurring opinion, Justice Scalia said, the rule that frames this case, that police can stop you, that every time the police stop you, they can frisk you for a gun. He said that rule would have offended the founding fathers. The noble, brave men who wrote our Constitution would not have suffered the indignity of being, searched just because there might be a gun on the premises. But Scalia said, what they didn't know is that today we have guns that are big enough that can fit in your pocket, that can kill you really fast. Well, muskets couldn't fit in your pocket. They didn't know there could be a gun that was so small. So even Scalia said we can't go with originalism in that case because they didn't know about these small guns that you can hide in your pocket. Well, they also didn't know about AR-15s. So why are we looking for similar regulations? Similarly, by the way, in 1791, if you beat your wife, this is terribly tragic, I don't mean to make light of this, but if you beat your wife, you were more likely to get applause than be arrested. So they had a whole different view of, I'm overstating that a little bit. But
the women didn't have any rights, and they were considered the property of the men they were with. So, I mean, that's another way of saying it.
Yeah. Wives are property of their husbands. Yes, that was the case. So their view on domestic violence was completely foreign to ours.
Right.
What smart person in 2023 would say the validity of laws regulating guns and domestic violence should be looked at by 1791 standards? Like, it's such a stupid, ignorant, nefarious, dumb thing. And that's what bothered Justice Jackson. And it bothers Kagan and Sotomayor just as much. But my sense is, with the liberals, because they're outnumbered 6-3, they take different avenues. They have so many points to make. They take different roads.
Yeah.
So today the road was for Jackson to criticize Bruin because Kagan and Sotomayor had other objections. She was great today, Pete. I got to tell you, she's been great consistently. she may turn out to be one of our finest justices.
Ketanji Brown Jackson.
Yeah, I'm really, and the other thing that I'm impressed by her, the other thing that impresses me about her, and this is really getting right to the kind of nut of things about being a Supreme Court justice. I can tell that she is toggling back and forth between respect for prior cases, which, you know, as an institutionalist, one would have, even if you think the case is wrong, and complete incredulity that any human beings could come up with an historical test this stupid. And that's a hard thing if you're actually in the institution, right? So if my colleagues do something that I'm really opposed to, and I think is really, really bad for the law school, I have to be a little careful on how I articulate that, because I'm going to be working with them for the next, that's how Justice Jackson is toggling back and forth. Scalia didn't care about that, by the way. Scalia didn't care about that, and that's why he pushed Justice O'Connor to the left, and that's why he pushed Justice Kennedy to the left. He pushed both of them left. So Jackson is fighting that, and I feel bad. That's a hard job. Like, if my law school did something really, really stupid, and I had to go out in public and talk about it, it'd be hard. I'd have institutional loyalty, plus I'd have loyalty to the not stupid. I see Jackson struggling with that, and that's interesting. And I find her very thoughtful.
I appreciate your thoughts and analysis on any of the current or prior Supreme Court justices, including the newest Judge Ketanji Brown Jackson. Interesting to hear her arguments today about a case that she wasn't on the Supreme Court to decide, much less the others. But the bottom line here, if there is one, would seem to be, Segall, that the Supreme Court is not going to allow this to go forward. The headlines across all of the people who I think you and I, well, you respect and I respect them too, have come to a conclusion. What do you think in terms of
what I saw on Twitter today? I was a little busy during the argument, but what I saw on Twitter today was virtually unanimous agreement among even those who are very strong gun rights folks that the Supreme Court is going to reverse the Fifth Circuit and uphold this federal law. Now, they may do it in ways that narrow the law or something, but the other thing is the lawyer today for the Rahimi, the lawyer was really, I'm sorry to say this, but he was really bad. And it's interesting that that this court seems to not like really. When conservatives lose in this court, it's usually because the lawyers are really bad. And this lawyer wasn't good. One other thing about I want to talk about Justice Roberts today, because I'm getting nervous about him. He asked a question today that was he's not a dumb questioner, right? I mean, Roberts, whatever we think of Justice Roberts, he was considered one of the finest oral advocates ever in front of the Supreme Court. That's liberals, conservatives, moderates, everybody thinks that. He was a shoo-in for the court for that reason. And whatever you think of him, he's a smart guy. I mean, I dislike him intensely, but he is a smart guy. At the very beginning today, he asked some question about, what about someone who goes 5 miles over the speed limit? Could they be disarmed?
And well, if someone who drives 30 miles an hour in a 25 mile an hour zone, does that person qualify as law abiding or not?
Right, for purposes of disarming them. And my point is that's such a bad look. He's really comparing domestic violence to speeding 5 miles over the speed limit. Like, it's a dumb question on the merits, but it's also a really bad look. I mean, this case is serious. This guy shot at people. I mean, shot in the air and threatened people and threatened the mother of his child. I mean, this is a serious thing. And Roberts is asking about speed limits? I mean, come on.
Well, he's trying to say in that case, if you break any law, does that mean you should?
But nobody was arguing that. Like, that's that. I mean, if he had said something, white collar crime. If he had said, what if someone commits some relatively minor, not a huge scandal, but a minor white collar crime, an accounting fraud crime, do we disarm those people? Right. Okay, maybe we can have that conversation. It's still bad taste. But comparing the speed limit to domestic violence didn't work either. Like, it didn't. It fell flat. It was bad. It was awful. Bottom line on today is the Fifth Circuit opinion was so hopelessly terrible. The lawyer today in front of the Supreme Court was hopelessly terrible. And I can't imagine a New York Times headline, Supreme Court strikes down federal law disarming people under domestic violence protective orders. That's a hard headline to imagine So that's the Mark Tushnet test. Mark Tushnet is a professor at Harvard, emeritus. He's my mentor kind of when I was young. And that was his always, until Barrett came on the Supreme Court, I think that test was pretty good. Can you imagine a New York Times headline? Unfortunately, with a 6-3 conservative majority, that test no longer applies, but it applies here.
So there are two other issues we wanted to talk about with you today. You were writing over at Dorf on Law under a title, Judge Bill Pryor, Racism and Runaway Federal Judges. You've talked about Judge William Pryor, the Chief Judge of the 11th Circuit Court of Appeals, several times here. You've written about him for a long time. He's the protege, I can't speak today, of one former Attorney General, former Senator from Alabama, Jefferson Beauregard Sessions. Judge Pryor speaks at all the right-wing think tanks, Heritage and Federalist, and he argued apparently in 97, more than 16 years before the Shelby County gutted a part of the Voting Rights Act, you write, that the entire voting rights law should be repealed. There's so much more background and history about this guy. Lay out a couple of more details before you talk to us about why today we're talking about Bill Pryor.
Yeah, this story is going to get this story is almost surreal. Like if this were a movie, nobody would believe it. And just to give a brief preview, it has the Thomases in it, racism, everything. It's an amazing story. Bill Pryor is just a really, really terrible human being. In 1997, he testified that he thought the Voting Rights Act should be repealed. It was 9 years after that a unanimous Senate not only didn't repeal the Voting Rights Act, but reaffirmed it.
Right.
So 9 years after this man said we should repeal this law, a unanimous Senate reauthorized it, and George Bush signed it and said we need it. I mean, this guy is 3 standard deviations to the right of both George Bush, the second, and the United States Senate. Think about that for a minute. Now, he's from Alabama, and that shows. So and one more thing about him. I was asked to talk at the National Federalist Society convention last year on affirmative action. And I was asked to speak on day 2. My panel was on day 2. And a Trump judge, Judge Kevin Newsom, who I like and respect, was the moderator of that panel. Judge Newsom is a colleague of Judge Pryor. They're both on 11th Circuit. The day before I got there, Judge Pryor opened the conference. It was the first thing was him. He was the opening speaker, big deal. And in that opening speech, he called out by name and insulted by name in a mocking and dangerous way Dahlia Lithwick, Mark Joseph Stern, Steve Vladeck, who wrote the Shadow Docket, and a couple other liberals. And he did it in a mean, disgusting way. Those Federalist Society meetings, like mine and his, are on YouTube. This was a dangerous thing for him to do, to call out those people by name as a sitting federal court judge to the crazies who are watching those videos. When I spoke the next day, I want to give Judge Newsom his deserved thing here. I called Judge Newsom and I said, Judge, I don't want to do anything to make you feel uncomfortable, but I think I want to say something about Judge Pryor. Do you object to that before I start my affirmative action talk? And he said, no, Professor Segall, do whatever you want. He said, Eric, do whatever you want to do. This is free speech. Do what you want to do. That was big of him. It was. And so I started by talking about how dangerous it was what Judge Pryor did.
Yeah,
so
I remember that. That was a really that was a very integrity-filled action for you to take. I think I had talked to you about that. I think you might have been looking for a funny line.
Yeah, I was. I was also asking your advice. Do you think I should do this? By the way, the Federalist Society audience was completely respectful of my taking
good
judgment. All right, so let's go back. 2017, Jane Mayer, who wrote the book Dark Money, which is a book about all the,
investigative journal, New Yorker, campaign finance, campaign money. Yeah.
She's a very well-respected.
Yep. One of the most.
I believe she wrote a bestseller. I'm not positive, but I think she did. So it's hard to write a book that's kind of a little bit academic and a bestseller. Like, that's not an easy thing. She did that. Anyway, she reported for the New Yorker magazine that a woman named Crystal Clanton at Turning Point USA. Can you tell your audience what Turning Point USA is?
It's a conservative organization run by Charlie Kirk, and it's kind of trying to get younger people to come to the
conservative. Really, the word you want to use?
It's a right-wing Christian nationalist fascist movement that really tries to recruit young folks and has a lot of young people involved. Yeah,
it's a white nationalist organization.
And it's a grifting, thing. They make a lot of money at their conferences and shit. Yeah.
So Jane Mayer had she says she has photocopies or text message. She has the actual text messages of an employee of that company saying, "I hate all black people. I'm done. I'm fucking done." So she publishes the article, and the woman has to leave Turning Point. Now, at the time, they said she was fired. Now they're kind of changing their story. It doesn't matter for our purposes. She's too racist for this white nationalist organization. She's too racist for this white nationalist organization.
Right.
So naturally, the very next thing that happens, and I'm not making this up, she has to leave Turning Point because she's too racist for basically white nationalists. She goes to live with Clarence and Ginny Thomas, who give her a job. I'm not kidding. That really happened. Okay. So
would they have known? Was that reporting?
Yes. It was in the New Yorker magazine. Of course they knew.
So Jenny and Clarence Thomas took in a woman who had said at one point.
Yes. Who eventually said, "I hate black people. I hate all black people." Jane Mayer is in possession of the text messages. I have not seen the text messages.
I feel like it's important to mention that she was given the opportunity to apologize or something, and never has, right?
What she said was that's not who I am. That's not what I sound like now or as a teenager. She'd never said I didn't say it. And more importantly, she didn't say I'm sorry. Pete, if she had said, "Okay, I did that when I was 16. I was stupid. It was wrong. I would never do it again. And I really deeply apologize," we wouldn't be here today. None of this conversation would be happening.
I mean, I've said it about several other ethnicities, not black folks, but I was young and stupid, and it was all based on what I'd seen on TV. No,
all she had to do. That's all she had to do was say that. Right. Anyway, she didn't. So she goes to the Thomases. So the next thing we know, she's living with the Thomases, and we just found out this week, I think, that she was actually working for Ginny on her social media stuff or something. Then she goes to Antonin Scalia Law School, of course. Where else would she go? She goes to Antonin Scalia Law School, and then she gets clerkships both. So the way it works in law school is you get your clerkships if you're going to clerk for a judge after law school, more or less your second summer of law school out of 3 years. She gets two offers, one from a district court judge in Alabama and one from Chief Judge Pryor. Now, it turns out Chief Judge Pryor has sent 15 clerks to the United States Supreme Court to Justice Thomas, That's more than he sent to all the other justices combined. He and Justice Thomas clearly have a shuttle system going on where Pryor tries out the clerks and then sends them to Justice Thomas. So all of that happened. Okay. Now, jump ahead. When the news about Judge Pryor hiring her came out, a woman in the Washington Post, and I'm going to knock, it might have been Ruth Marcus, but it may have been somebody else. I don't remember who it was. But one of the Washington Post journalists did a big story on it, which got me interested in it.
And then it was Ruth Marcus. You linked to it.
Good. It was Ruth Marcus. And she was just saying, wait a minute, hold on. How can the chief judge of the 11th Circuit hire a woman who allegedly said, "I hate black people, I hate all black people"? Leaving aside law clerk duties for a minute, there are African-American and black people in that courthouse who have to deal with Judge Pryor and her in numerous different ways. How can he hire somebody who said, "I hate all black people"? So she wrote this column. I wrote my piece, which got some attention. Some other people wrote. And all of that eventually prompted some members of Congress, I believe, to write to an administrative body that runs the United States courts and says, "You need to investigate this. This is terrible." Okay. The next thing that happens is, of course, the 11th Circuit can't investigate it because that's a conflict of interest, and that's the right decision. So they sent it to the Second Circuit, which is in the Northeast, and in 9 working days, it was 2 weekends plus 9 days, the Second Circuit said, without saying they talked to the woman and without saying anything else, and Judge Pryor has never mentioned anything publicly about this, they said, "Not a problem, case closed." And it was such a sham. It was such a horrific sham, and many of us wrote about what a horrific sham it was, that a few months later, they said, "Do it over. This was so bad. Do it. At the very least, talk to the relevant people. Talk to Jane Mayer. Find the text messages."
There's more, by the way. Other claims of disturbing behavior by this woman. Mediaite described a Snapchat message featuring a photo of a man who appears to be Arab and a caption written by Clanton that reads, "Just thinking about ways to do another 9/11," like he was a creative.
Now, again, I want to be really clear about this. People make mistakes, and when they own those mistakes, then we live in a different world.
Yes.
She has never owned the mistake. She has never owned it.
And by the way, she's allowed to think whatever she wants if she wants to work at the grocery store, if she wants to work at a software company. Like, it's not illegal for her to have these views, but if she's going to work for a judge in this case.
It's actually much worse than that. But let me finish the procedural stuff, then I'll get to that. So they say, do it over again. Okay. You know what Judge Pryor says, and the district court judge said?
And do the investigation of her over.
Do the investigation of Judge Pryor hiring her over. Yeah. We're not investigating her. You're right. She didn't break any laws. She didn't violate any laws. She's an asshole, but she didn't violate any laws.
Yeah.
No, the investigation is, why did Judge Pryor and this other judge hire someone who said these things, which obviously is something the public needs to know. Now, Pryor could have at that point, and this is where I get to the character of the man, which we already know is terrible, but this gets really bad. So at that moment in time, Pryor could have said, you know what, let's do a full investigation. I talked to her. I talked to her friends. I talked to the Thomases. I did all these things. I am absolutely convinced she's a good person. I'm convinced she didn't say these things, and I had every right to hire her and leave me alone. If he had said that, I'd be like, all right, that's stupid, but at least it's not what he said. What he said is, don't investigate. This is illegal. You have no jurisdiction the second time around to do this. Now, I don't care if he's right or that's a complicated issue, and we can't even judge it, Pete, because the reason Judge Pryor argued you don't have jurisdiction is because of something else that the administrative body did that we don't have access to. We can't even see it. So Pryor basically shut this down. And so then the Second Circuit came out saying even though we were asked to look at it again, we're not looking at it again. What's his motivation there? I want to get in his head. Why would someone who hired a woman who allegedly said, I hate all black people, why would he shut the investigation down instead of defending what he did? I mean, it's really terrible. And now it gets personal. And here's how it gets personal. The reason I've written 4 blog posts and one someplace else op-ed about this is for this reason, aside from the fact that it should offend all good-thinking people. Pete, the 11th Circuit came about in around 1978. Prior to 1978, the 11th Circuit didn't exist. There was a 5th Circuit. And that 5th Circuit was the entire South, basically. It was Florida, Georgia, Texas, Louisiana, Mississippi. Now, it was divided into 2 because it was too big. I started clerking for the Northern District of Georgia, the trial court, in 1983, and the 11th Circuit in 1986. Because I'm so freaking old, when I clerked for the 11th Circuit, Pete, I met the judges whose houses were bombed when they desegregated the South in the 1960s. Wow. People think Brown desegregated the South. That's not true. 9 years after Brown, the South was 98.3% segregated. 98%. What happened was Congress did some help with the Civil Rights Act, and then really brave lower court judges enforced desegregation orders. And their houses were bombed. Their family members were threatened. People with names like Frank Johnson and Elbert Tuttle, and my favorite name of all, of course, Judge Wisdom, which is the best name for a judge of all time. And these were really, Pete, these were Southerners. These were men who grew up their entire lives in the segregated South, who risked their lives to end segregation. The 11th Circuit is the 5th Circuit, the 11th Circuit's birth is the 5th Circuit. The fact that we went from Judge Wisdom, Judge Tuttle, Judge Johnson, and these amazingly courageous men whose houses were bombed to a dickhead like Judge Pryor, who was so arrogant that he won't even publicly explain why he hired a law clerk who it wasn't like Segall said it. Jane Mayer is this reputable. Now he considers her part of the liberal establishment, and I'm sure some traitor to the country. But the reality is, it's not Segall talking. This is Jane Mayer, who is a universally recognized journalist. She said she has text messages that this person said, I hate all black people. And he hired her anyway and won't explain it. He won't fucking explain it. I mean, it is just, and I'm thinking about my memories of with these Southern judges who were very elderly when I was with them, very frail, but all of them telling me and the other clerks stories about how they did what they did and what it took. By the way, one of those judges, Judge Tuttle, on a separate note, came to my law school and told a story about how he was born in Hawaii. He was there when the first car ever got to Hawaii and what that was like, which is really a fantastic thing. But leaving all that aside, The Fifth Circuit tradition in the 60s and 70s of enforcing desegregation was courageous, it was right, it was honorable. And now the chief judge of the successor court is just awful.
And it's a kind of, it's a story of, or a narrative of how far this court has gotten, the court that covers that region of the country, at least, in its extremity, and its blatant, open.
Yeah, I mean, the 11th Circuit is nowhere near as bad as the Fifth Circuit, even though it's half Trump judges. But the Fifth Circuit, yes, the Fifth Circuit is so far to the right of this Supreme Court, which, if you think about it, really, what is to the right of this? I mean, is there a level of sanity that is to the far right of this Supreme Court? I would say no. And the Fifth Circuit is right there. The Fifth Circuit is at that place, and that's why they keep getting reversed. They do.
By the Supreme Court, right? Yeah.
Well, so anyway, so it's really, on a serious note, I would really appreciate a public statement by this life-tenured federal judge explaining how he, in Alabama of all places, how, and by the way, Montgomery, Alabama, where he sits, Montgomery, Alabama, my understanding of history is that of all the places in the South, Montgomery might have been the worst when it came to, and then that's why the Montgomery, but that's why a lot of things happened in Montgomery, because it was known as the worst place. And he is just a stain. He's just a stain. And then he gets standing ovations from the Federalist Society for making fun of Dahlia Lithwick.
Well, I mean, we are a very racist, sexist country, and in those halls of those rooms, they're that much more. So it's just a example of, different values.
It is kind of my backyard, and it's sad to me. It's really, really sad.
All right. Well, the final thing that we have to talk about today is the one I'm saving for last, because I feel like it's boring. But you've paid close attention to this, and
you think it's boring. I think it could be the end of our country.
Section 3 of the Constitution. Well, this is titled Section 3, Originalist Chaos, and Why Donald Trump Should Not Be Constitutionally Disqualified from the Presidency. The reason why I think it's boring is because no part of me thinks that any of these cases in any of these states are going to go anywhere, and I just want your simple answer first before the more important, I think, somewhat convoluted. But you write, over the next year or so, numerous courts and state election officials are going to be asked to disqualify Donald J. Trump from being president again because he engaged in an insurrection and thus is ineligible under Section 3 of the 14th Amendment. Lawsuits have already been filed in Minnesota and Colorado seeking to keep Trump off the ballot in those states. In the next few weeks, I'll be speaking at Stanford and University of Minnesota on this issue to prepare. I've read numerous articles by prominent law professors trying to ascertain the original meaning of Section 3. We've talked about this. You've made the case here. I don't know if I agree with you or not. I don't really care. It doesn't matter what I think. I'm saying,
stop.
Okay.
You need to care. And I'm having PTSD because we had this conversation before. I hate to keep bringing this up on you. I don't mean to, but I just have to make the point. In 2016, you said, I don't care about Donald Trump. He's never going to get the nomination. And then you said he's never going to get the presidency. And you said it very strongly. And I kept saying, you don't understand Oklahoma and you don't understand rural Alabama. I could have said you don't understand Judge Pryor, but I didn't think to say that at the time. I probably should have. This is a big issue, Pete.
I think it was right then. I think I'm still right about that. Statistically, it was hold on. Statistically, it was such a fluke. I don't buy the argument, by the way, comparing my prediction, which is just like everybody else's, about this. I'd rather not talk about the politics of the possible outcome of election and more about the likelihood of, in your expertise, any state disqualifying. Because
I think Colorado's going to do it like in 2 weeks.
So wait, are you telling me that there's going to be a state that is going to prevent Donald Trump from being on the ballot?
Yeah, I think there's a very good chance of that.
There's a good chance of it, and you think it's like
Pete, slow down, my friend, my good friend, slow down. Okay, it only takes one state to get this issue to the Supreme Court of the United States. If any state disqualifies him, Trump will appeal, of course. And the Supreme Court will have to take that case, and will have to take it probably on an expedited basis, because we can't, as Rick Hasen has written all over the place, and others too, we can't have this uncertainty next November. So this is Pete, you got to trust me on this. This is going to be in the newspapers. This is going to be front page headlines.
But just a hypothetical. I just want to know if Colorado says he's disqualified, he can't be on the ballot. Then it goes to the Supreme Court.
First it goes to it goes to the Colorado. That's right. If the Colorado Supreme Court does that, every state's different in its procedures. But yes, if Colorado,
but then the Supreme Court will throw it out, and Trump will be on the ballot.
I think that's probably what's going.
That's why I don't care about this. Because that's what you probably think is going to happen. I'm not going to spend too much time thinking about this, but I'll give you however long you think.
So the reason, this is actually a story. The Trump part is the most important part, but there's also another part of the story that I think is interesting from a media public perspective. So what happened? So this has been, we've known this was coming for a long time. Section 3 was written to disqualify people who engaged in the Confederacy from holding office. It allows Congress to remove disqualification by 2/3 vote of both houses. I would like Congress to do that tomorrow. I would like the Democrats to say, we'll vote so that Trump can't be disqualified. That would win them the election. If the Democrats did that, they'd win the election. But leave that aside for the moment. Congress twice passed laws saying Confederate people can now hold office. In other words, they use their power. But, and it's barely been used since. It was used once a year ago to disqualify somebody who was running for some local office, who was in the insurrection, who actually attacked the Capitol on January 6th. Pete, what happened was a few weeks ago, maybe 3 weeks ago, a month, two card-carrying, absolute FedSoc originalists wrote a 126-page article saying Trump is disqualified now. No court even has to say it. Just like if you're 33, you can't be president. If you're 33, you can't be president, right, and you're disqualified. They said same thing here. If you're engaged in an insurrection, you're disqualified. Now, that's stupid because we know what 35 means, and we don't know what 30. We don't know what insurrection means. I think it's a very hard case to make that Trump's speech on 1/6 was an insurrection. I think that's a hard case to make. But leave that aside for the moment. They write this 126-page article. Adam Liptak writes about it in the New York Times, and all of a sudden we're off to the races. And now there are law school events at Stanford, Minnesota, and 5 others that I didn't go to. The most famous law professors like Lawrence Tribe are joining with ex-judge. Pete, let me ask you a question about this. So Lawrence Tribe in 1995 was the most famous con law professor in the world. Today he's emeritus and older, but he still has 1 million Twitter followers, and he's still very well respected by a lot of liberals. Tribe joins with a conservative former federal judge to write a series of essays in the Washington Post and other places saying we have to use this to disqualify Trump. Now those are serious people saying serious things, Pete. I mean, Tribe's a serious person. Mike Dorf was his GRA. This former Judge Ludig is a serious person.
Sure.
He's no dummy. They want Trump disqualified.
Sure.
These conservative FedSoc people want Trump disqualified.
Right.
That's really interesting all on its own. And then the fact that the media took this 126-page, completely legalism type article. It wasn't Segall talking about what's right and wrong, as I think we should do in con law. It was talking about 1869 and cases and Chief Justice Salmon Chase from 1860, blah, blah, blah. But Pete, it became a huge media thing, which is why I was at Stanford talking about it in other places. The reason it's a huge thing, Pete, is there are some serious arguments that he should be disqualified. Now, I don't think he should be, because I don't think you take the vote away from 70 million Americans, that's who supported him last time, unless you're certain. And there were too many open legal issues here. We're not certain. Because right after they wrote that 126-page article, guess what? 2 other people wrote exactly 126 pages and took the opposite position on every issue.
Because of those...
Am I boring you?
No, not at all, actually. But the interpretation that you have...
Yes.
And the
I don't have an interpretation. I'm not interpreting anything. I'm with Judge Posner. We don't interpret the Constitution when it's unclear.
Well, what you're interpreting is insurrection.
No, I'm not. I'm not doing that. I'm telling you, I'm not doing that. What I am doing is what is best for America today. And what is best for America... Listen.
But that's not illegal.
Pete, let me say something. The president has to be 35. And that's just a fact. And we should all live by that until we amend the Constitution. Every state gets 2 senators. And we have to live with that until we amend the Constitution. But the provisions of Section 3 in about 6 different places are subject to varying interpretations. When equal protection, due process, freedom of speech, establishment of religion, when those kinds of phrases are at issue, we're not interpreting anything. We're creating.
But I feel like, no, but just to be clear, I feel like the reason you're so, and many others, so animated and jazzed up about this is because how interesting it is to interpret this.
No, that's not my reason. No, I couldn't give a fuck.
But no, you're not listening to me, I don't think. And I want to be clear. I think Donald Trump is going to most likely be in jail. He could die, right? He's old. Joe Biden could die. But Trump could also be in jail.
Yeah.
There's other things that are far more likely to happen than this. And since you already answered my question that no matter what these different states decide, the Supreme Court will overturn it. He will then be on the ballot, potentially even in jail. And so I don't know, I'm just not that interested in belaboring this thing because it's so specific, by the way. It's not like all the other issues that I've always talked about with you that I'm much more interested in, frankly, because they impact so many different types of people's lives in terms of this could be applied to so many other people, this law, this outcome. This is the former president. This is about whether or not someone can run for president if they participated in or an insurrection. And I just don't think that that's a thing that we have to deal with on a day-to-day basis is the final point I would make about why I'm just not that concerned with this.
And let me, are you done?
Yeah.
Okay. Everything you just said was wrong. So first of all, there's already been like televised hearings on this issue that a lot of or live streamed, from Minnesota Supreme Court, and they were really struggling. Like they were trying to figure out what to do. This is an interesting legal issue for a zillion reasons, leaving aside the practical considerations. I don't care about the legal stuff, and especially not on your show. So forget that. Pete, when I say the Supreme Court is certainly going to not disqualify him, I could be wrong. And by the way, if a state does disqualify him and it goes to the Supreme Court, how much coverage will that get? You can imagine. That's worldwide. That's everything. That's the whole kit and caboodle right there. And by the way, I'm going to play devil's advocate for a second. My friend Ilyas Soman, who's been on your show a couple of times years ago, he's a very thoughtful, fed-sock libertarian. But he's a thoughtful guy. And he also thinks Trump's disqualified, should be disqualified. And the reason the reason he thinks that, and the reason that a lot of people think this, Pete, is not a frivolous reason. This is I don't view it this way, but this is the argument. It's a democracy-enhancing device. Section 3 of the 14th Amendment says, if you're so disloyal that you try to overthrow a rebellion, insurrection against the government, then you don't get to hold office again because that's too dangerous. That's exactly where we are.
I don't care.
You don't care?
No, I don't. Okay. I really don't. I don't think this is in any way going to happen. I don't think it's likely. Any of these things. I don't think any of these states.
We're surprised to hear that liberals have been coming after me like there's no tomorrow for my position that he should not be disqualified. Like I've been attacked.
I mean, everybody wants him to be disqualified. Like the idea that
I don't want him to be disqualified.
A lot of yes, of course, liberals want him to be disqualified so he can't be on the ballot. That's what they want. They want him to be arrested. They want him to be dead. They want him to be gone. We want him out of our lives. We definitely don't want him. And if he breaks the law, any law, he should have to face the consequences, including this one here that he can't be on the ballot because breaking law. I'm looking at these other cases where he's been indicted. I think they are going to far be more impactful and supersede anything about whether or not he's going to be on the ballot. As a matter of fact, I don't think he's even going to win Iowa at this point. I think the polling around this guy, I think he might not even win the nomination possibly. So, I just don't think that this situation is why.
Let me try one more thing and then we'll call it a day. Forget Trump for a second. The general idea of Section 3 of the 14th Amendment, that it only applies, by the way, to people who have taken oaths to uphold the Constitution.
Even more specific, like why we're not going to have to see it again.
Well, hold on. You don't think we're okay, we're going to do a very big picture thing here in a very short period of time. Pete, our country is hanging by a thread right now. It really is. I know so many thoughtful people who think if it should come about that Trump is reelected somehow, then we have to create a new country effectively. I think they're right.
I'm not worried about it.
Hold on, let me finish. I'll let you finish. Hold on. So there's that piece of it. But forgetting that, whatever legal decisions come out of this, Pete, given that our country is hanging on a precipice, are really important because you can't just ignore Section 3. If Donald Trump had marched with that gang if Donald Trump had gone from the podium into the crowd, marched with them to the White House, and helped them break into the Capitol, then he absolutely should be disqualified and he shouldn't be on the ballot. And what we're facing in 2024 is a whole lot of uncertainty unless here's something you can't change, Pete. CREW, I forget the acronym, it's an ethics group.
The Citizens for Ethical Government, something like that.
They have a lot of money, and they are going to go to every state. Like, they're going to try this everywhere until it works. They are. So you can't run away from this issue. It's going to be in the news. You don't have to cover it, but it's going to be in the news. They're going to every freaking state, and they're going to win one of them. And then it's going to go to the Supreme Court. And the stakes of that are unbelievably high, not just because of our moment in time, as Whitney Houston would say. That was pretty good, wasn't it? Not just for that moment in time, but going forward, we're not done with people trying to overthrow our government.
Yeah, but the reason why we're not, of course we're not done, but it has to be someone who's taken an oath. So what, a Marine? Who's taken an oath?
Anybody who ever worked for the government.
Anybody who ever worked for the government. Okay, that's one category, and then they're going to have to commit some kind of treasonous act, insurrection, and then they're also going to want
actually aiding and abetting.
And then they're gonna run for office, and then everybody's gonna laugh them out of.
That's what happened. He was disqualified. New Mexico disqualified someone.
Right. So it's just not going to happen again. I don't think there's any. This is Donald Trump. It's a one-time thing that he participated in insurrection. He took the oath, and that he's running again for president. I don't see this being an issue that we need to be concerned about in terms of somebody else doing it or what the precedent set here is.
Well, I have an idea.
All the other people who were there on January 6th, like over 1,000 of them, went to jail, so they can't run for office because they're in jail. And by the way, I think he organized. He told the big lie. He promoted January 6th. Right. He gave the speech. He told him to go up there. So I think he absolutely is guilty of insurrection. He promoted the concert. He's the concert promoter.
Let me be clear. I think there's a reasonable argument. There's a reasonable legal argument that he should be disqualified, that he engaged in insurrection, that he took an oath, that he is in fact an officer of the United States, because some very smart law professors are saying he isn't, so it doesn't apply to him at all, or the vice president. My point is that none of that matters. I don't give a fuck. What matters is, what are we going to do politically with this man, for whom, this is a fact, 3 million Americans voted for last time. And how we handle this moment in time is this question is absolutely important. But I will concede you this. Let's let your audience decide. If they want to hear more about this, I'm happy to come back and talk more about it. If they're bored by this like you are, I'm happy not to. I am telling you that 6 months from today, we're likely to be covering this as a front page story.
I'm not, just to be clear, bored by it as much as I'm not prioritizing. I'm spending a lot more time thinking about his indictments, thinking about the case this week, thinking about the Department of Justice, thinking even about Judge Cannon and what she is or is not doing. I mean, like, those to me are in terms of priorities and certainly in terms of legal issues that I can even begin to comprehend, much less bring on.
All of those cases, except for maybe the Florida one, but even that one, all of those cases have to go on appeal. He's not going to be in jail before next fall. There's no chance.
Oh, I absolutely do not think that is true, based on tremendous, several analysts.
Well, he may go to jail if he wants to, and based on his behavior yesterday, I'm starting to think he wants to go to jail. But he's not. He may go to jail for contempt of court, but he's not.
That's not what the people who specialize in this are saying, and maybe they're being dishonest.
Okay. Well,
I've heard a lot of people say he's going.
The case that's farthest along, of course, is the New York case. That's a civil case. There's no jail time. So forget that one. All right. In Florida, he clearly violated a law. I know a lot about classified documents, and what he did was illegal.
But if he's found, even if he doesn't go to jail, he will be found guilty before the election.
I think so.
Yeah, that's not that. Listen.
Do you think people care?
Absolutely do.
His poll numbers go up every time he's indicted.
Yeah, I do. I think that's going to be. It's a year away. I'm not buying it until.
Wait for the Twitter feed on this podcast. Anyway, one last thing about Donald Trump. So I've sadly experienced in my last 3 or 4 years, witnessing people go from being fully there to not being, to having either dementia, Alzheimer's, or something. I've had numerous personal experiences that have been very painful for me, including, I'll be honest, with my dad, including Judge Posner's Alzheimer's, and then several other people I don't want to name publicly. He's definitely losing it. I mean, it is obvious. I mean, he is definitely not the media savant he once was, and he is definitely losing it. My question to you is, and then we get into the podcast, do you think his supporters care at all?
No.
Okay.
No, I don't.
Well, that's really, since he had 70 million supporters last time, that's really scary. And that's why people like conservative FedSoc law professors who are really afraid and understand this country, some of them from the rural parts of this country, that's why they're pushing this. Look, this is not a liberal, Crew is liberal, but this is not a liberal agenda. These are conservatives who are pushing this thing.
Yeah, well,
you know why? Because they're scared. They're scared he might win again. You're not scared about that. You weren't scared last time. You need to be scared.
No, that's not fair. Not fair. And I want to be clear with my audience. I'm terrified. I was terrified then, and I'm terrified now. What I won't do to them and to myself is say you have to live in fear. I think two things can be true. This is what I believe. And today is election day. And I've spent hours and hours and lots of money I didn't have supporting local candidates. And what I think is we may not win any seats tonight. We may win all the seats tonight. But when I spend time worrying and biting my nails and being terrified, it doesn't help me. So of course I'm afraid of Donald Trump winning. But I'm not. I don't think I need to go publicly, certainly, much less even privately, hand wringing, telling people this could happen. I think you have to be afraid and do the work, but not live in that fear. Because what is living if that's how you're walking around all the time? But
Pete, that's fair, and of course, I accept all. I get all of that. That's well said. And that's your lane, and you're great at it, and it should be your lane. And I wish you would run for president. I mean, although your past might be a problem, but maybe not. That isn't the point. My lane is constitutional law and constitutional practice.
Sure, yeah.
And I'm saying to you, the stakes that are going to, because we can't avoid this. He could die tomorrow, then we wouldn't have to have this. But assuming he lives and is still running for president or running for any office, I have to deal with this issue.
But don't
wait, hold on. And what I found, by the way, by having a guy named Mark Graber on my podcast, Mark is an excellent historian of the 14th Amendment. But he thinks we should decide these cases based on today, not the 14th Amendment. That podcast got really well received, Pete. People, and we were talking like really kind of technical law for a lot of it. People care about this. And I think in some sense they really should, because we're talking about the possibility of public officials at some level of government disqualifying a former president of the United States and the current GOP frontrunner. Now, let me finish the sentence. Even if only one state does it, and even if it's reversed by the Supreme Court on on case-specific grounds, even if all that happens, the Republican Party will use this weapon in the future. They've already started. Marjorie Taylor Greene has already started. So the success or lack of success of the 50-state effort to disqualify him is going to have major political repercussions in the future. And what I want to say to my friends on the left and the right is, please don't do this. This is the wrong approach.
Yeah, well, they're obviously doing it, and the outcome remains to be seen. But I'm not going to be thinking nearly as much about that as I am all of these other cases, which I think will have far more consequences on the election and the future. I mean, he should have been impeached twice.
100%.
So
I was told that McConnell actually wanted to have an insurrection charge. He wanted that to go forward, and he couldn't get the votes, so he didn't.
Oh, interesting.
That was interesting to me. No, of course he should have been impeached.
Now, am I by a cognitive decline? When you talk about Trump or Biden, I think that if you put somebody out in front of microphones and on television all the time and obviously he's getting older, they're not as charismatic and so on. But, if most of the time behind the scenes and even on camera, he's got his wits about him. I watch Trump's rallies. He's killing. He kills at half these things, doing bits.
No, he kills at half these things.
Well, he kills half the time at these things. We don't watch necessarily all of it. But the point is, I don't think like it's. I'm not sure what you're.
Yeah, I think you are. I think you might be. Doesn't mean you're wrong. You could be right. I think you're in a distinct minority when you're not worried about the ages of both of these men being president of the United States.
Oh, I'm definitely worried about both of them. I get criticized for being ageist. I don't think that you should be even thinking about running for public office. I think, and when people, by the way, talk about how important experience is, I will never, ever disagree with that. I just think that super experienced, wise old man should be on the sideline and whispering in Maxwell Foster, Alexandria Ocasio-Cortez's ears and running their campaigns and helping them craft policy. I don't think they have the energy to be out on the campaign trail doing what I think leaders need to do. And I'm watching them doing it locally. And I watch Obama do it. I've watched lots of people do it, which is give high energy speeches and motivate people and inspire people. And more importantly, be living when the consequences of their policies are going to be most impactful. That's why I think young people should be far more included and engaged and less apathetic. And, but when you're 80 years old and you're running a national campaign, much less a local campaign, that's hard. I mean, I don't think and it's not personal. I don't even think I'll live that old.
No, I agree with every syllable you just uttered, although I would add, not just running the campaign, running the country is 24/7, and it's not something that someone.
You got to be able to nap. If I don't get my nap in, if you wake me up during my nap,
me too. I didn't get my nap today. Can you tell?
Show doesn't get made. All right, I love you. It was great. I hope everybody loves it. I think they'll probably agree more with you than me, and that's fine as always.
Thank you, my friend. I really liked it. Have a good day.
Well, are you still there? Did you enjoy that? Was it tedious? Was it monotonous? Was it okay? Was it interesting? I thought it was. It kept me engaged almost all of that conversation. Obviously, we had some disagreement there. You may agree with him or me on that. I would probably lean towards him. You care about being right at all, but we are curious here at Stand Up, and that's what we're always trying to do, is get to the bottom or different solutions to intractable, sometimes problems that we're all facing together. Try to understand it all. Eric Segall, always good to help us do that. Go say hi to him on social media, listen to his podcast, and I've got another one about to drop with Tim Wise. Had a great conversation with Tim. I've got the ladies of the Hue on deck as well, and much, much more coming your way. Thank you for your support. Can't do it without you. Go sign up for a subscription if you haven't already. Patreon.com/Pete Dominic. Also can't do it without John Carroll singing us in and out each and every day. Take it away, John.
Well, there's a whole lot more of us who know us right. They'll keep right on ignoring us if we keep sitting tight. We got to open up the window to let in some light. You gotta stand up. That's right. We got to rise up. You got to stand up. You got to stare the devil straight in the eye. We got to let him know it's his turn to go. See it clear when all you hear is a lie. Don't get up off of your butt, get down off of your fence. And even if it ain't a very friendly audience, well, they'll begin to listen when you start making sense. And you stand up, stand up. Point your rifle to defend your town. Just stand up, stand up. You know they can't deny you what you're laying down. Boy, you better stand up, stand up. Show your face of every color, yellow, black, red, and brown. This is the place where every lost child will finally be found. There's only one thing to do before we stand our ground, and that's stand up, stand up. Well, the founding fathers saw a land for all. They had to stand up. They had to stand up. They had a keen imagination for a crystal ball, drawing all the plans of stand up. But all they had to go on was the time they were in, with other causes for laws, and since they weren't even sin, they knew that change was gonna come before the change could begin. They had to stand up. All right, they had to stand up. We got to stand up. We got to look the devil square in the eye. We got to let him know it's his time to go, and make it clear when all we hear is a lie. Why you lying awake wondering where the money all went? It'll be the cost of freedom that'll go unspent. You can see them flee the scene of that experiment. If you stand up, all right, we got to speak up, we got to reach up and raise your voice in every way you know how. Don't be toes up, you got to show up. Ain't no better time to do it but now. No need to pledge allegiance to no wanton tribe. Rise up, show obedience to the voice inside, and listen well and it'll tell you not to run and hide. It says stand up,